are going to look at the third arm of the government. Remember, in the presidency, I said there are three arms of government: the executive, the legislative, and the judiciary. You discover that in the whole system, the judiciary is the third arm, but a very important arm for that matter, because the interpretation, what the bias that the law has, is the pronouncement of the judiciary. So we are going to look at this session, and at the end of the day, you will understand. We look at the various courts in Nigeria, their powers, their jurisdiction over matters. So these are things we are going to see in this very section. The emerging posture of the judiciary for democracy. So judiciary is the backbone of the democracy. For instance, what is in the news? We've had an issue where courts of coordinate jurisdiction issuing different order on a particular case. The current matter is that of the recent suspension of the PDP national chairman. In that instant case, we had that a court in Port Harcourt gave the order for suspension, and another court coordinates the same jurisdiction, but from another place, from far north, gave a counter order. It's not supposed to be so, because they are the courts of the same ranking. If an order will be sought, it ought to be a higher court. So this course will help us to understand the operations of these levels of law, so that as another person, or as a person who has the knowledge of these things, you can be able to advise people and tell them this is what it ought to be. The roles of judges in democracy in Nigeria. Like I said, this arm of government is very, very important. And the head of each of every court is seated, whether be a panel of jury or a judge. So we are going to look at their role. So during the military regime, the military regimes, in their resolve to keep the judiciary down, led the country to operate under such position that we are again and hamper the dispensation of justice. We know that during military eras, court orders are not obeyed. Where even they obey, they are obeyed haphazardly. But one thing they were unable to do at that time is they were unable to ban the judiciary arm of government. So what they normally end up doing, they will ban the executive and the legislative, but the judiciary will always be there, even though they might not be given free hand to do their function. So the role of judiciary cannot be overseen. So in Nigerian context, however, it is not the province of judges to make law, but to interpret and apply law as it is. So their duty is not to make law. What they do is to interpret this law and apply them. But it is now the duty of the executive to make sure that such pronouncements and orders are implemented. Whether it be English law, statute law, customary law, or so forth, the role of judges in Nigeria is essentially to apply the law as made by the legislator. This is the view of positive school of law, or the positive theory of law, which is the law is as it is made, whether good or bad on this chain. So they establish the law. Let's go to the next slide. We want to look at the roles of some of these judges. Now, first of all, constitution of status. In the course of carrying out this constitutional duty, courts are frequently asked to interpret documents. Now, in this context, when you talk of courts, we are referring to judges. A matter can be brought before a court. It means that matter is before a judge. So it is the duty of the courts per se to give interpretation to a document, construe the meaning of a statute, determine the liabilities, rights, duties, obligations of parties in a suit, whether civil or criminal. Statutes are not always very clear in its meaning, given the intention of the legislature. The task of discovering the intention of legislator as contained in the statutes in order to give effect is not just making law, but being able to interpret those laws. Once the legislation is done, it is now left in the hand of the judge or judges to give interpretation based on circumstances that led to the enactment of such law. So these are things that judges will look at. They look at various issues before they come to conclusion on particular matters. There are rules of interpretation. We are going to look at the major rules of interpretation. So these are the rules that guide our judges to interpret provisions of the law, say the Constitution, any other one for that matter. One, there's what we call, the first one is the literal rule. Under this rule, the intention of the law must be given on its face, and as it appears. Just interpreting it as it is in the law book. That is the literal rule. So, but in interpreting a matter, the judge must have to look at these various rules. He must have had the processes, had the facts about the case, and look at these various rules and know the rule that best suits that circumstances and that very matter. So now the first rule we talked about is the literal rule. So you can go ahead and still read about the literal rule. The second one, we have the golden rule. So it's still another rule that in this golden rule, it means that where the literal meaning of words will lead to an absurd result, the court should adopt an interpretation that avoids the absurdity. Now, when the court looks at the literal rule, and discover that if you just give this judgment based on what the letters of the law, it will lead to absurdity. So that's where it now goes to golden rule. For example, some of the merits of the golden rule include it enables us to avoid absurdity by adopting an interpretation that will promote the intention of the parliament thus maintaining law and order. So law beyond the literal aspect of law, there is what we call the intent. What the makers of that law had as their intention to make such law. Very, very important. So this rule applies it in making subject. So you can look at some other reasons why you can use golden rule. So if there's any question, you can as well ask. Now the next one is the mischief rule. The mischief rule means that a statute should be interpreted to deal with the mischief it was enacted to cure. This requires that the judge shall look at a statute to see the intention of the parliament, interpret it to remedy the wrong in the society that it is meant to correct. Like I said, every legislator is meant to cure a defect. So in this rule, the judge will always apply to see that whatever judgment is going to deliver as a result of dispute emanating from such an environment, he must make sure that it goes back to the intent of that enactment. Lest it means that the whole exercise is exercise in futility. So it's very, very important that a judge will look at this aspect of rule before he comes to conclusion in a matter. The next one. You can look at this one, you see some merits of mischief rule of interpretation, like I said when I was trying to explain it, that if the judge fails to look at the intent, the reasoning for such enactment, and just look at literal and give the judgment, he might just make a lot of mistakes. And at the end of the day, the society will pay for it. So at the end of the day, you find out that the rights of people may be tramped upon. So no judge will like to do that. So it's very, very important. So the issues with the mischief rules, there are issues with it too. You can look at them. You can throw open some floodgates for individuals to do a lot of things. No, in every system, people will always like to capitalize on short force or loophole to which was well intended to make a lot of unnecessary pronouncement. That's why it's called mischief, so that people not key into such openings to do something that are not good with law. So there are other rules of interpretation. The statutes must be read, so you can go through and go through them. You see some, but these ones we've looked at are the ones that are basic and they are very important. So you must have a full knowledge of these ones that we mentioned. Let's go to the next slide. Like EDU's generic rule, we have these things are legal terms. They are legal jargons. At times when you pronounce them, you may end up beating your teeth. But you must have to still try as much as possible to get them. Like the context rule, codification. But let me look at this codification. A code is a species of status which strive to sum up the provisions of existing legislation. For instance, the principle of common law and the doctrine of equity on a particular subject to be a single whole. The code is viewed as the detailed compilation of applicable laws, blended and aligned with the principles, custom, the common law, and the rules of equity in particular field of behavior. So that's what we call codification. You know, like in law, if you look at the law, stricto sensu, you see the society may still jam, will still be in trouble. So in such cases, everything comes in to mitigate the ills of the common law. If you follow the common law as it is brutal. That's what equity does. So a codification is a kind of bringing both the common law and the equity together to make sure that the justice delivery is fair and is fair to all and sundry. So codification has been suggested in Nigeria for the various system of customary and native laws in order to articulate and reconcile the differences so as to reflect the common practices of the people of Nigeria or some part of it. Such code will have the effect of legislation in whatever field and customary law it relates to. So like I said before, now there are local laws that are peculiar with some environment. I gave an example of what is happening in the north. There are some laws that are obtainable in the north. Here, they are not issued. There are ones that are here. When you get there, they are not issued. So a kind of codification is such that we bring all these laws together and specify the peculiarities so that even when because they say ignorance is not an excuse to the law. If you, as a citizen who has the right to travel from where these things are lawful and to a place where it is unlawful, without codification, you'll be able to get yourself abreast with the system that is oppression in a particular place. So it is very, very important. So it's part of it. Thank you. So in summary, we've been able to look at the duty of judges and the courts as it concerns democracy. I hope that